All eyes were fixed on the stark contrast unfolding before them. On one side sat Judge Amy Coney Barrett, esteemed for her conservative and meticulously controlled demeanor. On the other, Congresswoman Jasmine Crockett, a lightning rod for advocacy on racial and social justice, known for her passionate, direct style and unyielding commitment to reform. In this hallowed hall of justice, a contentious hearing was about to commence regarding charges of contempt of court levied against Congresswoman Crockett. These charges, some argued, were not grounded in legal necessity, but were instead politically motivated attempts to silence a fiery voice of progress. Judge Barrett presided at the bench, a study in composure and formality. Her reputation for resolute, austere governance was evident in every measured gesture and clipped word. Dressed in a dark, impeccably tailored robe and with her features set in a mask of impersonal authority, she radiated the chilling coolness of old-school jurisprudence, a stark counterpoint to the vibrant, unapologetic energy that Congresswoman Crockett exuded. As the courtroom settled into a tense, expectant silence, Judge Barrett's tone was both admonitory and patronizing. With a calculated air of superiority, she began the session by intoning, "This hearing is convened to address serious allegations of contempt of court, and I expect every participant in this proceeding to exhibit the solemnity that our judicial process demands. Let me be clear. Disrespect toward the court will not be tolerated." Her words, crisp and devoid of any overt warmth, resonated through the chamber and sent a ripple of nervous anticipation among the observers, who had braced themselves for a clash of rhetoric. Seated at the defense table, Congresswoman Jasmine Crockett appeared as a stark foil to her esteemed judge. Clad in a sharply cut suit that melded professional elegance with a hint of rebellious flair, she maintained a calm, unflappable expression. Her demeanor was one of controlled confidence. Her eyes, dark and unyielding, communicated a quiet determination. As the proceedings began, whispers could be heard amongst the gallery. Many expected Crockett's impassioned oratory to erupt into a storm of vociferous rebuttal against what they saw as an affront to free speech. Yet, as the session progressed, it became evident that Crockett was not there merely to defend herself in a battle of brash words. She was there to dismantle her accusers with crisp facts and the relentless clarity of legal precision. With an ironic calm, Judge Barrett then issued her challenge. "Ms. Crockett," she said, her voice laced with a dismissive tone as though addressing a mischievous child rather than a veteran lawmaker. "You have 7 minutes to present your case. Use them wisely, for the consequences of any further disrespect will be severe." The words, delivered with a trace of amusement and condescension, drew a ripple of murmuring laughter from some corners of the room. Yet, before the judge's patronizing remark could settle fully, Crockett's cool response cut through the tension like a scalpel. Leaning forward slightly, her eyes locked onto the judge's with an unyielding gaze and without raising her voice, she replied calmly, "7 minutes? I'm confident that I'll need only 6 to have you reconsider your assumptions." In that instant, the atmosphere shifted imperceptibly. A definitive spark was lit, and the stage was set for an intellectual showdown between two women whose very different worldviews now converged in this august hall. Overhead, the ornate dome of the Supreme Court, rich with symbolic carvings and the weight of judicial precedent, stood silently witness to this historic exchange. The audience, composed of legal experts, journalists, and members of the public, sensed that something rare was about to occur, a moment when the ironclad facade of tradition might finally yield to the probing force of truth. In those first few moments of the hearing, the tension was electric. Every whisper, every shifting glance in the gallery, spoke of the public's deep hunger for genuine accountability and the unyielding courage of those who dare to challenge entrenched power. Judge Barrett's eyes narrowed imperceptibly as she prepared to continue. She had expected a typical display of impassioned anger or even a shouting match, but here, in this polished arena of justice, Crockett's measured retort had not only undercut the judge's foregone conclusions but also underscored the battle between two competing philosophies. Barrett's conservative worldview, rooted in formality, tradition, and a strict adherence to procedure, now encountered a formidable force of progressive reason. In that defining moment, every spectator in the courtroom realized that what was unfolding was not a mere legal formality or a petty personal confrontation, but a profound clash of visions for the future of justice in America. Thus began the day's proceedings, a contest of intellect and principle, where the power of persistence and knowledge would soon challenge the status quo. As the judge prepared to call the next matter to order, the echoes of those first fateful words lingered in the air, heralding a confrontation that would not only test the limits of legal rhetoric, but also redefine the balance of justice. The atmosphere in the Supreme Court chamber, already charged with anticipation from Judge Barrett's haughty opening remarks, shifted perceptibly as Congresswoman Jasmine Crockett prepared to speak. There was a hushed expectancy in the room, a collective breath held in anticipation, while Crockett rose to address the bench and the gathered audience. With a measured yet firm cadence, she began, "Your Honor, esteemed colleagues and members of the public, I stand here not merely to defend my honor but to defend the very principle of justice that our nation cherishes." Her voice, steady and resonant, carried a power that defied her relatively young but storied career. In her opening statement, Crockett methodically dismantled the politically charged accusations leveled against her. She explained that the charges of contempt were not based on any breach of judicial decorum or omission of duty, but were instead a thinly veiled attempt to silence a voice on issues of racial and social justice. "The charges before this court," she declared calmly, "arise from a series of events where political motivations, not legal transgressions, have dictated the narrative. I will demonstrate, through a presentation of indisputable documentary evidence and legal precedent, that these accusations are less about the maintenance of courtroom order and more about an effort to suppress dissenting views that challenge the status quo." Her tone never rose to anger, never strayed from clarity. It was as though she were reciting from a legal brief prepared with unwavering purpose. Crockett continued, "I refer to the fundamental principles enshrined in our Constitution and the legacy of countless legal decisions that protect freedom of speech, assembly, and the right to dissent. Just as landmark cases such as Tinker v. Des Moines and New York Times Company v. Sullivan affirmed the necessity of protecting even controversial expressions, so too must we ensure that no political opinion, no matter how unconventional, is nullified through baseless legal maneuvers." Her words, chosen with precision, rippled across the room, forcing even the most skeptical onlookers to re-examine their assumptions. Taking a deliberate pause, Crockett walked slowly to the podium and activated a multimedia presentation behind her. Charts and graphs began to flicker on the large screen, illustrating a timeline of events that clearly showed the origin of the charges was intertwined with politically motivated decisions. "Notice," she said pointedly, "the abrupt introduction of these contempt charges coinciding with my outspoken advocacy for equitable policies and my persistent calls for accountability within our institutions. These actions were not mere lapses in protocol but were systematically instigated by political adversaries seeking to undermine the very discourse that drives our democracy." Her presentation displayed side-by-side comparisons of official documents, press releases, and internal memos, a veritable dossier of evidence that contorted the narrative into revealing its true colors, political vendetta masquerading as legal procedure. Every fact, every figure that Crockett articulated was delivered without an ounce of hostility. Instead, her calm demeanor invited the audience to reconsider preconceived notions about the sanctity of the charges. "I ask you to consider," she continued, "that true contempt for the court is not found in exposing hard truths about systemic injustice, nor in challenging discriminatory practices, but in the deliberate manipulation of our legal system to silence voices that cry out for reform." Her deliberate reference to past judicial opinions, imbued with a precise reading of statutory interpretations, carried an authority that transcended the youthful years of her tenure. The clarity with which she enumerated each legal misstep in the prosecutorial narrative not only undermined the very basis for the contempt charges but also reasserted a vision of justice that was both inclusive and accountable. At one point, when Judge Barrett interjected with a dismissive remark hinting that Crockett's arguments were irrelevant, the Congresswoman merely tilted her head slightly in acknowledgement and replied softly but pointedly, "Your Honor, my remarks are founded upon the rule of law. I am here not to engage in a battle of personal egos but to lay bare the truth that lies at the heart of this case." There is no need for raised voices when the facts speak eloquently on their own. In that moment, her words caused a visible stir among the spectators. Even the judge's cold countenance wavered ever so slightly as he processed the undeniable logic of her response. Crockett then shifted her focus to systemic issues beyond her individual case. She meticulously outlined instances of bias within the judicial apparatus, presenting documented evidence of similar cases where political motivations led to questionable charges. "This," she said firmly, gesturing to a series of printouts on the screen, "is not an isolated incident. It is part of a broader pattern wherein our system's fundamental balance has been subverted by those who wield power for partisan ends. I stand before you to say, if the integrity of justice is to be maintained, then every action, every charge, every decision must be measured not by political expediency but by the unwavering application of our laws." Even as she spoke, the atmosphere in the courtroom grew tense. Some members of the public shifted uncomfortably in their seats, while a few murmured agreements. The hushed murmur of whispered conversations gradually ceded to an air of introspection. Crockett's unwavering delivery and precise articulation of legal principles undermined the narrative her critics had so eagerly advanced. She was not there to incite strife. She was there to speak plainly about the injustice being perpetrated in the name of law. Her measured cadence and reliance on concrete evidence prompted even Judge Barrett to take notes, his previous overconfidence softening in the face of the persistent truth. For the remainder of her allotted time, Congresswoman Crockett continued to unfold her arguments. A seamless fusion of legal theory, factual evidence, and a call for systemic reform. Her presentation was less a personal defense and more an impassioned plea for a return to genuine justice, a reminder that the authority of law must always serve the people, not the other way around. With each fact laid bare, with every legal reference meticulously introduced, she chipped away at the foundation of the contempt charges, leaving little doubt that this was a case driven by political animus rather than any true breach of courtroom decorum. As her initial 7 minutes approached their end, the courtroom fell eerily silent. Crockett concluded with a final, resonant declaration. "I stand here not as an adversary of the system, but as its fervent guardian. If the truth you hold is indeed the measure of justice, then I trust that by the end of these proceedings, every seat in this courtroom will reflect that conviction. For it is not the volume of our voices that defines us, but the clarity and veracity of our words." In that charged moment, as the echoes of her measured speech reverberated across the grand chamber, the challenge had been irrevocably set. The stage was now in motion for a confrontation that would transcend mere personal defense. It was a battle for the soul of the judicial process and the moral compass of the nation. In the midst of the unfolding proceedings, Congresswoman Jasmine Crockett shifted the focus of her rebuttal from personal vindication to a sweeping critique of the systemic bias embedded within the judicial framework. With an unwavering composure and unyielding clarity, she began to lay out the larger pattern that, she argued, revealed that the contempt charges against her were not isolated missteps but a symptom of an institution increasingly compromised by political influence. "Your Honor," Crockett began, her tone deliberate and resonant, "the charges you have brought before this esteemed court are not the result of any willful disregard for decorum on my part. Rather, they are the product of a political maneuver designed to silence a voice that consistently challenges the imbalance of power in our society. I ask you to consider the broader context in which these proceedings take shape and to examine, with unflinching honesty, the true nature of the system that has brought us here today." Her words hung in the air, measured and formidable, as she unfurled a series of well-researched documents and printed transcripts before the assembled jurors and members of the public. Drawing attention to a series of past cases where charges of contempt had similarly been brought against outspoken public figures, Crockett articulated a stark comparison. "I refer, for instance, to cases in which dissent was equated with disobedience. Consider the chilling precedent set in a case name omitted for anonymity, where an individual was censured not for any legal infraction but for daring to question the established order. In that instance, the judiciary itself tacitly endorsed the notion that the mere act of challenging prevailing policies, even under the protective banner of free speech, could constitute contempt. When I compare that precedent with my own situation, The similarities are too glaring to ignore. Her voice grew steadier as she mapped out specific examples. A list of cases where political critics faced punitive actions on flimsy evidence or on the basis of subjective interpretations of decorum. Raising her eyes slowly toward the gallery, she pressed on. I ask you, esteemed members of the court, do we not see a disconcerting pattern? How many times in the past decade has the right to dissent been conflated with contemptuous behavior? How often have legislators, activists, or outspoken community leaders been ostracized under the guise of protecting the sanctity of our judicial process? Such actions, when viewed in totality, speak to a deliberate effort to stifle voices that are critical of, or even antithetical to, the entrenched power structures. This is not merely about me, nor solely about a single act of alleged contempt. It is about the health and future of our democracy. Crockett then deftly guided the court's attention to a meticulously prepared timeline that interwove the events leading to the accusation with concurrent political maneuvers in the corridors of power. On a large projection screen behind her, rows of documents and press releases cascaded in sequence. Behold, she stated softly, this chronology shows that the contempt charges were not precipitated by any dereliction of duty or breach of courtroom behavior on my part, but rather emerged immediately following one of my most vociferous public criticisms of recent policy decisions. Notice, for example, the abrupt issuance of these charges after I delivered a statement at a Capitol hearing where I cited numerous instances of bias in public policy. One cannot help but infer a direct correlation, a punitive response aimed at curbing political dissent. Her evidence was bolstered by quotations from landmark judicial opinions and legal treatises on the right to free speech. Quoting from seminal works such as New York Times Company v. Sullivan and other seminal cases, she argued, the First Amendment exists to protect even those opinions most challenging to the status quo. It is the bedrock of any society that claims to cherish democracy. To penalize dissent in this manner is not only a deviation from established constitutional principles, but it also undermines the very foundation of our legal system. When the law is wielded as a weapon against principle, rather than as a shield for justice, then we must ask, who is truly in contempt here? Is it the individual daring to speak out, or the system that seeks to silence her? Her delivery was measured, bullying neither with raised voice nor provocative rhetoric, but with a disciplined, logical sequence that forced the court to reevaluate its assumptions. She cited statistical data illustrating the disproportionate number of contempt charges levied against minority political figures and activists when compared to those retired from mainstream power structures. The numbers do not lie, she said softly, and the pattern is clear. When voices that challenge racial and social inequities are heard, a backlash is mounted under the veneer of judicial discipline. Her eyes, bright and determined, swept the room as if to command every listener to look beyond their preconceptions. At one point, as Judge Barrett attempted to interject with a curt remark about maintaining courtroom decorum, Crockett countered almost imperceptibly yet unerringly, Your Honor, true decorum lies in the respect we show for the law and for the truth it is meant to uphold, not in the suppression of honest critique. That simple statement, delivered in a tone that was neither defiant nor subservient, seemed to resonate deeply with the audience. Her words were not a challenge to authority per se, but a call to realign that authority with its foundational duty, to guard the principles of justice and equality. Further reinforcing her point, Crockett detailed how the charges were being advanced based on ambiguous criteria that, when scrutinized, turned out to be highly subjective. If we examine the official documentation, she pointed to a highlighted section of a printed transcript, we see several clauses that hinge on interpretation rather than on a clear, universally applicable standard of conduct. Such ambiguity allows for the politicization of legal norms, a tactic that is as dangerous as it is antithetical to our cherished ideals. Her voice maintained its steady cadence, each word a deliberate strike against the overreach of partisan legal maneuvering. As she concluded this segment of her defense, Crockett left no doubt that her intention was not to defy the court out of mere defiance, but to insist upon a truth that the system had long neglected. I stand before you, Your Honor, as an advocate for all those who have been marginalized by a system that is too often guided by expediency rather than by the immutable tenets of justice. My case is a mirror, reflecting not only my own experience, but also the systemic failings that must be addressed if we are to claim the mantle of fairness in our society. The courtroom fell silent as the gravity of her argument sank in, and even Judge Barrett, with all her conservative resolve, could not help but show a trace of contemplation in her measured eyes. In that moment, the clash of worldviews was no longer a personal battle. It had become an imperative for re-examining the very standards by which justice was administered. Crockett's methodical dissection of bias, her presentation of meticulously gathered evidence, and her unwavering adherence to constitutional values had transformed the proceedings from a narrowly focused legal dispute into a clarion call for comprehensive judicial reform. The audience, now fully immersed in the debate, watched in rapt attention as her voice, steadily, unassumingly powerful, challenged the established order and beckoned them to consider who, truly, was violating the balance of justice? As Congresswoman Jasmine Crockett pressed forward with her potent arguments, the atmosphere in the Supreme Court chamber grew palpably charged. Every word she pronounced, every legal precedent she referenced, carved deeper into the veneer of authority that Judge Amy Coney Barrett had so carefully cultivated over years on the bench. Now, with facts and figures laid bare for all to see, Barrett's customary cool had begun to show the first signs of strain. Seated at her elevated bench, Judge Barrett's normally steely gaze faltered slightly. In moments when she had earlier exuded a polemical superiority, her eyes now betrayed a nervous flicker of uncertainty. The courtroom, a space where tradition and authority were meant to reign supreme, seemed to be slowly bending to the force of Crockett's logic. The judge's well-rehearsed reserve, once impenetrable, now wavered as the overwhelming clarity of the Congresswoman's evidence disrupted the usual order. After a particularly compelling point was made by Crockett, one that laid out a precise timeline of political events intertwined with the initiation of the contempt charges, there was a collective intake of breath in the room. Crockett's deliberate pace and unwavering tone had rendered the previously normalized power structure vulnerable to scrutiny. With documents and official memos projected in vivid detail, she revealed how the charges were engineered to align with politically motivated agendas. A hush fell over many in the gallery, and even longtime legal observers exchanged glances that spoke of astonishment. For a moment, Judge Barrett's fingers tapped nervously on the mahogany surface of her bench. She understood, perhaps intuitively, that each successive revelation undermined the framework upon which she had built her interpretation of court decorum. Barrett attempted to reassert her authority. In a measured attempt to regain control of the proceedings, she opened her mouth to interject with a curt remark, something to remind everyone of the solemnity and uncompromising nature of the judicial process. However, as soon as her words reached the air, they were drowned out by the precise cadence of Crockett's continuing presentation. The Congresswoman moved seamlessly from one exhibit to the next, her voice steady as she read a carefully curated excerpt from a landmark case that had long protected political dissent. Barrett's interjection, when it came, was halting and strained. "Ms. Crockett, while I appreciate your observations, we must maintain," she began, her tone betraying a vestige of the earlier condescension. But her sentence was cut short by a well-timed projection of official legal documentation that Crockett had submitted. The displayed document, emblazoned with citations and signatures, left no room for dispute. The judge's pen paused over her notes. There was a visible moment when her well-practiced mask of imperturbability cracked, her eyes darting briefly to her legal pad as though searching for an escape from the spiraling tide of argument. In that moment, the entire courtroom was riveted by the transformation of the proceedings. The conservative torchbearer of judicial formality, once so confident in her ability to maintain order, was now scrambling for control over a narrative that seemed to have a life of its own. The public gallery, which had earlier bristled with anticipation for a dramatic confrontation, now witnessed an unaccustomed vulnerability from the court's presiding officer. Some spectators shifted in their seats, a few whispering that the day's events were rapidly rewriting expectations of judicial decorum. Despite her visible discomfort, Judge Barrett was obligated by strict procedural rules. She recognized that while she could express disapproval or issue warnings regarding decorum, she had no legal foundation to blunt the factual thrust of Congresswoman Crockett's evidence. Every attempt she made to temper the presentation was met, within moments, by another piercing fact or an incontrovertible legal reference that left the opposition's case even stronger. At one point, as Crockett recited a passage from a federal ruling on the protection of dissenting voices, the judge leaned forward and then recoiled, unable to mask the impact of those words. Internal tension was evident in Barrett's measured but burgeoning stutter when she addressed an alleged misinterpretation of court procedure. With her normally smooth cadence disrupted by nervous pauses, she tried to emphasize that court rules could not be selectively interpreted to suit any political agenda. Rules exist to ensure uniformity in the application of justice, she asserted, her tone too rapid and clipped, betraying her inner agitation. But Crockett's calm rebuttal, underscored by detailed references to statutory law and judicial interpretations, rendered the statement hollow. The judge's defenses, instead of reinforcing her position, only underscored the irony of attempting to enforce decorum by means that now appeared dubious in light of the overwhelming evidence of political motivation. As the minutes ticked by, palpable shifts in the courtroom's dynamics were evident. A quiet murmur began to replace the earlier tension, a murmur not of resistance or anger but of contemplation. Even several of the media representatives, watching live, leaned forward as if to catch every nuance of this unprecedented courtroom drama. Legal observers scribbled notes, and the audience's collective gaze seemed to ask, who, then, is the true guardian of justice? The answer, illuminated by Crockett's dispassionate presentation, grew clearer with every passing second. Barrett, for her part, struggled to regain her customary composure. Yet even as she adjusted her glasses and attempted a firm nod, the forces at play in the courtroom were inexorable. The rules of evidence and precedent that she was so proud to administer now worked against the very show of authority she had hoped to project. Her earlier attempts at condescension and warnings of dire consequences dissolved into the background of a conversation governed by the stark logic of documented truth. The internal resolve that had long enabled her to command unwavering respect was undermined by the incontrovertible data and the sheer moral clarity articulated by Congresswoman Crockett. In that fateful period, a brief, tumultuous segment in an otherwise routine hearing, a profound metamorphosis occurred. What had been anticipated as a standoff between a rigid custodian of tradition and a fervent political crusader was, in fact, evolving into a transformative exchange that questioned the very basis of authority. It was as if the scales of justice, long tipped by partisanship and decorum, were beginning to rebalance themselves in favor of veracity and fairness. And though Judge Barrett continued to enforce the procedural rules, it was unmistakable that her ability to stifle dissent was waning. Thus, as the picturesque architectural details of the Supreme Court watched silently in witness, the judge's struggle for control became emblematic of a deeper conflict, a confrontation between a system that prized appearances over substance and a voice that demanded to be heard for its intrinsic truth. With every hesitant word from Barrett and every resolute statement from Crockett, the sounds of a new era of judicial introspection stirred in the hallowed chambers of American justice. The courtroom's atmosphere reached an almost tangible crescendo as Congresswoman Jasmine Crockett signaled that she had reached the final phase of her testimony, an exhibit of irrefutable official documents that would dismantle the very foundation of the contempt charges. With a deep, steadying breath, she advanced toward the large projection screen that had now become her platform for truth. In her hands, she held a meticulously organized portfolio bound by evidence. Printed transcripts, certified court orders, and correspondence from eminent legal authorities. The gallery, already silenced by the impact of her earlier arguments, leaned forward in anticipation as she began her presentation. Your Honor, esteemed members of this court, I now submit for your review the official documents that have been filed over the past several months by independent legal bodies and judicial oversight committees, Crockett announced, her voice resonating with authority and calm determination. These documents, drawn from public records and verified by independent auditors, unequivocally demonstrate that the contempt charges levied against me are founded not on any misbehavior or breach of court decorum, but on a series of politically motivated actions aimed at undermining my legitimate advocacy for racial and social justice. With measured precision, she directed the court's attention to the first set of documents displayed on the screen. The images depicted copies of internal memos from a government review committee tasked with monitoring political bias in legal proceedings. "Here," she said, "we see that shortly after my vocal criticism of certain policies at Capitol Hill, an internal directive was issued recommending that a case be brought against me on grounds of disrespect for the court. This memo, signed by officials whose names have been redacted for confidentiality, explicitly acknowledges that the initiative to file these charges was politically expedient rather than legally sound." As murmurs of astonishment rippled through the gallery, Crockett continued seamlessly, her tone shifting to an even more resolute timbre. She unveiled a second batch of materials, certified transcripts of previous Supreme Court proceedings that established the acceptable boundaries for dissent and the expression of political opinion. "In these transcripts," she explained, "the court has on numerous occasions reaffirmed that expressive content and vocal criticism, when conducted respectfully, are not grounds for contempt. In fact, landmark decisions reassure us that the right to critically engage with state power is an essential element of our democracy. Yet, the current charges seem designed to conflate passionate advocacy with contempt, a dangerous misinterpretation that this very court has repeatedly cautioned against." The projected slides shifted, now displaying detailed comparisons between established legal precedents and the language used in the present charges. Crockett pointed out specific phrases that, under judicial scrutiny, revealed glaring inconsistencies. Notice, for example, that the official charge cites a pattern of deliberate disregard for courtroom protocol. However, when compared to past rulings, such as the dissenting opinions in cases like Brandenburg versus Ohio and Tinker versus Des Moines, the language falls drastically short of defining any behavior that warrants penal action. "I submit that this discrepancy is not accidental but deliberate, a tool designed to discredit dissent and intimidate other voices of reform." Her fingers deftly toggled between documents, and she then presented a previously sealed report from a bipartisan commission established to investigate potential abuses of judicial power. "This report, Your Honor, concludes with a resounding assessment that the actions taken in my case represent a misuse of legal processes to achieve political censorship." It states plainly, "The imposition of contempt charges under these circumstances undermines the principles of impartial justice and constitutes an affront to the democratic values upon which this nation was built." The document's stark language reverberated across the room, its implications undeniable. Even those who had remained neutral until now could not ignore the weight of the words. Crockett's eyes swept over the courtroom as she prepared to close her evidentiary onslaught. "Lastly, I offer you the final piece. A letter from the Attorney General's office, inadvertently leaked and later authenticated by the Office of Legal Counsel, which explicitly addresses the case at hand. In this letter, the Attorney General himself admits that the grounds upon which these charges were constructed were politically expedient and devoid of objective legal merit. He further states that the actions taken against me were intended to silence legitimate dissent, rather than to preserve the sanctity of court proceedings." A charged silence fell over the room as the projection of the letter illuminated the backdrop of the chamber. The judge's face, which moments earlier had been the embodiment of controlled authority, now exhibited a furrowed brow and an unmistakable hint of hesitation. The prosecutor, too, shifted uncomfortably, his earlier swagger now diminished under the scrutiny of these damning documents. The gallery, a mix of journalists, legal practitioners, and concerned citizens, erupted into a subdued wave of applause and murmurs of approval. Each document, each line of dated text and legal citation, served as a clarion call for accountability, a piercing spotlight thrown upon the injustice at the heart of the proceedings. Crockett's final words in this segment carried a weight that transcended the immediate case. "These documents," she concluded with a voice both quiet and powerful, "prove beyond any reasonable doubt that the charges before this court were not a measure of maintaining decorum, but rather a politically motivated assault designed to suppress advocacy for justice. When truth is subjected to manipulation, it is not the individual who is in contempt. It is the system that has lost its way." In that decisive moment, the foundation of the contempt charges began to crumble. The official records, bolstered by the incontrovertible authority of revelation from independent oversight and high-ranking legal voices, left little room for alteration of the narrative. With her comprehensive presentation, Congresswoman Crockett not only debunked the charges against her, but also exposed the systemic flaws that allowed such politically repugnant maneuvers to take root. The courtroom, now abuzz with a new energy of realization, braced itself for the inevitable shift in the proceedings, one that promised to redefine the very essence of justice in this venerable institution. As the final exhibits continued to be displayed on the projection screen, the venerable courtroom seemed to be caught in a vortex of inexorable transformation. What had begun as a procedural hearing under the stern gaze of Judge Amy Coney Barrett was now teetering on the brink of an historic paradigm shift, a moment when the very authority of the court was being challenged by the relentless pursuit of sheer, unadulterated truth. In the wake of Congresswoman Jasmine Crockett's damning presentation of documents, a palpable change fell over the chamber. The previously austere silence of the courtroom was pierced by a rising undercurrent of astonishment and disquiet. Members of the public, legal scholars, and even veteran journalists exchanged wary glances and whispered remarks to one another. Their collective realization was unmistakable. Here was a case whose outcome would not be determined by the traditional exercises of legal decorum, but by the powerful, undeniable evidence of political overreach. Judge Barrett initially attempted to reassert her authority. With a force of habit born from years of confidently presiding over complex cases, she cleared her throat and tried to interject, "Order in the court." Her words, however, barely registered in a room already saturated by the weight of Crockett's evidence. Instead of the usual respectful silence, a subdued murmur of agreement rippled through the gallery as attendees nodded, many visibly moved by the undeniable logic presented before them. Emboldened by the public's reaction, Crockett's every word seemed to gain additional momentum. Her calm, articulate exposition of the internal memos, leaked directives, and certified transcripts had transformed the courtroom into a forum where facts triumphed over dictate. The judge, whose demeanor had once been the embodiment of impassive control, now found herself grappling with the very real possibility that her rigid adherence to tradition was, in this case, working against the interests of justice. The more she tried to steer the proceedings back into the safe channels of established routines, the more the room resonated with the truth of Crockett's assertions. In one particularly tense moment, as Judge Barrett attempted to emphasize the importance of maintaining decorum, her voice betrayed a hesitant quaver, a sound foreign to her usual measured intonation. A pair of seasoned court clerks exchanged quick, sympathetic looks, and even a few jurors shifted in their seats, as if to signal that they no longer perceived the proceedings as a mere formality. Instead, they saw an unfolding battle for the soul of the judicial system, with every piece of evidence meticulously dismantling the framework of politically motivated contempt. The once imposing figure at the bench now appeared vulnerable, her attempts to insist on the sanctity of court protocol rendered impotent by the overwhelming clarity of the official documents that Crockett had submitted. When she tried to interject with a comment about the preservation of institutional integrity, her words faltered under the sustained barrage of factual evidence. The judge's carefully scripted admonishments crumbled before the eyes of a courtroom that increasingly resonated with a collective, unspoken challenge. The scales of justice were no longer balanced by positional authority but by the irrefutable truth laid out before them. Officers, reporters, and observers in the public gallery began to shift in enthusiasm, some recording every word on their devices, others scribbling notes on legal pads, their expressions a mix of shock and admiration. When a prominent legal analyst in the gallery leaned over to remark quietly, "This is a turning point for our justice system," even the most stoic faces in the room showed a subtle sign of approval. The force of Crockett's meticulously gathered documentation had not only unveiled the political motivation behind the contempt charges, but also rendered the judge's earlier threats of severe consequences hollow. Within minutes, as experts stood by with their technical verdicts and affidavits confirming evidence tampering, the atmosphere grew electric with the realization that the hearing was now irrevocably shifted. Judicial authority, once the sole domain of tradition and decorum represented by Judge Barrett's steely command, was yielding to the power of transparent, well-documented truth. Pieces of high-stakes legal precedent and irrefutable internal affairs were now the dominating factors, leaving little room for any recourse the judge might have clung to in days past. In a final, visible moment of internal struggle, Judge Barrett's stern expression softened briefly into one of reluctant deference as she reviewed the documents on the screen. It was as though, in that split second, she acknowledged that the evidence, not her own authority, would dictate the outcome of this historic day. The tension in the chamber gave way to a quiet, almost reverent murmur of agreement from the gallery. What was once perceived as an attempt to silence dissent had been unmasked as an intimidation tactic, and the public's faith in the higher ideals of justice was being vindicated. By now, even the procedural formalities seemed to falter as the judge hesitated to interject further, her earlier ironclad resolve visibly in tatters. The once implacable sound of her gavel now echoed in the background as an afterthought, dwarfed by the resonant truth of Crockett's arguments. In that charged moment, it was unmistakable. The courtroom was no longer a stage for maintaining command by fear or tradition, but for witnessing the transformation of an outdated system into one that weighed truth above all else. As the final moments of the historic hearing dwindled away in the hallowed chamber of the United States Supreme Court, an almost surreal hush enveloped the courtroom. The atmosphere, once charged with tension and flickering hope, now surrendered to a solemn gravity that even the towering columns of the courtroom could not fully contain. Judge Amy Coney Barrett, her once imperious visage now haggard from the relentless force of documented truth, finally brought the proceedings to a close. With a measured and somber tone, she announced, "In light of the overwhelming evidence presented and the pronounced irregularities in the filing of these politically motivated contempt charges, I hereby dismiss all charges against Congresswoman Jasmine Crockett." Her words, though delivered in a controlled voice, carried a weight that seemed to reverberate off every pane of stained glass and echo through every corridor of the venerable institution. The judge's pronouncement came not with the harsh clangor of final judgment, but with an undercurrent of reluctant concession, a tacit acknowledgement that the truth, once unleashed, had upended long-held assumptions of judicial decorum and impartiality. For a brief moment, the silence that followed her declaration was as palpable as a heartbeat, punctuated by the soft rustling of legal papers and the quiet tapping of pens as court clerks hurriedly began updating their records. In that moment, the entire chamber was united by an unspoken understanding. The system had been forced to confront its own shortcomings. Congresswoman Jasmine Crockett, who had defended not only her own honor but the very spirit of free inquiry and unbiased justice throughout the day, slowly gathered herself. Without fanfare or the explosive rhetoric that had characterized earlier portions of her testimony, she rose from her seat. Her posture was impeccably dignified. She did not raise her voice, nor did she allow any trace of personal bitterness to mar her composed demeanor. Instead, with quiet resolve, she stepped forward to shake the outstretched hand of a court reporter in passing. Without uttering a single word, her silent exit from the bench area spoke profoundly of her moral victory. A victory firmly rooted in the unwavering conviction that truth must and will prevail, regardless of the obstacles the system may impose. Outside the chamber, the corridors of the Supreme Court buzzed with an almost palpable eruption of discussion. Lawyers, aides, and onlookers huddled in small groups, their voices rising in fervent debate as they recounted every salient detail of the day's exchanges. The once sterile silence of the courtroom had transformed into a hub of impassioned dialogue, where legal experts dissected each document, every timestamp, and each legal precedent that had been forcefully laid bare by Crockett's presentation. There were hushed exclamations of unprecedented and monumental intermingled with fervent declarations that this day, this very hearing, might be remembered as a watershed moment in the nation's legal history. In the days that followed, media outlets seized upon the unprecedented nature of the proceedings. Headlines blazed across newspapers and online news portals. "Justice speaks clearly and loudly," they screamed, capturing the exact essence of the event. Talk shows, social media platforms, and political commentators alike were abuzz with impassioned analyses and spirited debates over the implications of the hearing. The narrative that had once been shaped solely by established power structures was now being rewritten by a transparent flood of evidence, and by a resolute woman who had refused to be cowed by those very structures. As Congresswoman Crockett walked the long, echoing corridors of the Supreme Court to exit through the Westminster-style doors, she did so with a quiet humility that belied the magnitude of her achievement. Flanked by her aides, her every step was deliberate and measured, yet it resonated like the slow tolling of a bell that marks the end of an era and the beginning of a new age. Journalists and legal observers crowded the exit, eager to capture every nuance of her departure. Despite the swarm, she maintained her silence and composed demeanor, allowing her actions to speak for themselves. In the quiet aftermath of the hearing, the corridors became a war room of ideas. Heated discussions spilled over into nearby cafes and office spaces as legal scholars and civil rights advocates alike debated the systemic failures that had led to unjust charges in the first place. Many highlighted how the case had exposed an alarming trend: the politicization of judicial processes to muzzle dissent rather than to preserve the sanctity of honorable conduct. Community leaders and reform advocates argued that the events of the day served as an urgent call to action, a reminder that when the power of truth is stifled by political expediency, it is the very pillars of democratic justice that begin to crumble. Within the walls of the Supreme Court, retreating staff and solemn faces continued to reflect on the legacy of the day. For some, it had been a moment charged with catharsis, a vindication of the rights of every citizen to speak truth to power. For others, it was a stark admonition: the machinery of justice, no matter how venerable, is not infallible and must always be held to account. Yet among all these ruminations, one sentiment prevailed: that the hearing had irrevocably altered the public's perception of those who sit in judgment. In subsequent interviews and op-eds, voices emerged that painted the hearing as not merely a personal victory for Congresswoman Crockett, but as a seminal moment that redefined judicial accountability in America. Legal experts cited the detailed evidence and the brave, unpretentious manner in which Crockett had deconstructed the charges, heralding it as a blueprint for resistance against politically weaponized legal actions. Hashtags like #JusticeSpeaks and #TruthPrevails began trending on social media, and discussions in academic journals analyzed the implications of the proceedings for future cases. Back in the quiet of her office, far from the clamor of the public sphere, Congresswoman Crockett reflected on the events of the day. There was no grand speech or tearful interview, only the firm satisfaction of having stood for what was right. In her measured thoughts, she recalled the judge's initial challenge: "You have 7 minutes, use them wisely." And as she silently committed herself to the ongoing work of fighting for justice and equality, her mind echoed with the resolve that had brought her to this moment. In her heart, she knew that while the legal battle of that day had been won, the work for true systemic reform was only just beginning. This was not merely a clash of personalities or a battle between two formidable women. It was a transformative lesson for the entire system, one that illuminated how truth, when spoken clearly and presented with unwavering conviction, can dismantle even the most entrenched abuses of power. This was not simply a battle between women. It was a lesson for the entire system. Subscribe for more stories where truth prevails, even in places where you least expect it.